A very happy new year to everybody. Thank you so very much for joining us for our very first webinar of 2026. And I am very pleased to see that we have almost a full house. So thank you very, very much. Today we're going to be listening to a discussion on using arbitration and mediation to resolve maritime and logistics disputes. We know that logistics is becoming something really, really important as people sit in their offices and their homes and order stuff virtually. These things have to be moved from one jurisdiction to the other. And we do have somebody who practices in this field who would be speaking with us today. And I have one of my colleagues. I'm going to introduce my colleague who is moderating, and he would introduce our speaker. I can see both of them on my screen, so I'm very pleased. My colleague's name is Mark Wasunna, and a very special congratulations. He just sorted out his PhD. So, Doctor, we're very grateful to Mark for accepting our invitation to moderate this webinar. Mark is also an associate lecturer here in the School of Law. I didn't tell you my name. My name is Emilia Onyema. So I'm just going to hand over to Mark, and Mark is a member of the center, so he knows what he's doing. Mark, over to you.
Thank you so much, Professor Onyema, and thank you to the SADRC for hosting what looks to be another promising event. Allow me to take this early opportunity to introduce our speaker for today, Ms. Foluke Akinmoladun, who is in fact the managing solicitor of Treason Law Chambers, Nigeria, a legal practitioner, accountant, mediator, arbitrator, and chartered secretary with expertise in commercial, maritime, construction, and corporate governance law. Ms. Foluke is a GAR Global Arbitration Review 45 under 45 finalist for Nigeria, UN MIPAD honoree, and a recipient of the top 20 most influential female law firm founders in Africa 2020. And so that just goes to show you the caliber of the speaker we're lucky to have today. And so without much further ado, I'll allow Ms. Foluke to come in and present or to share her presentation for today. And then after her presentation, we'll go into an interactive discussion with the rest of the participants today, who can then engage with the presentation. So without much further ado, please, I'd like to welcome Ms. Foluke Akinmoladun to present on today's webinar. Thank you.
Thank you very much, Professor Emilia and Mr. Mark. I just want to confirm that I can be heard.
Yes, we can hear you.
Oh, fantastic. Great. So thank you so very much for this opportunity. I'm truly honored to be speaking on such a famous and well-known platform, the School of Oriental and African Studies in the UK. I remember when I invited a few friends and colleagues to register for the webinar, some of them said, wow, how did you make that happen? So I'm very grateful to Professor Amelia. Thank you so very much. Mr. Mark, can you kindly share my slides? Yes. While I go into a topic that I'm personally very passionate about? And I will do a very quick, about 30 minutes presentation and give time for us to ask questions, because I really think that it is in asking the questions and in looking at the opportunities that are available that we can really build our personal capacities and personal motivation which is very important if you're coming into a field that you're not necessarily very familiar with. So my topic today is on resolving maritime and logistics disputes through arbitration and mediation. So I'm going to be looking at it both from a global perspective, because maritime is a global business, and I'm also going to be looking at it from the perspective of the African continent, because there is a lot that is going on in that space. There's a lot that is going to be going on in the next couple of years, considering the fact that Africa has the largest youth population in the world. So as far as investment is concerned, as far as economic development is concerned, we're going to be seeing a lot happening in that space. So in terms of an overview of what I will be presenting on, I'm going to be speaking on the strategic overview of the maritime and logistics dispute resolution space. Then what are the key drivers? What are the things that cause disputes in the global trade that involves maritime and logistics? And in order to understand this, it's important to understand how important maritime and logistics is situated when we talk about global trade. Then I'm going to touch on the policy and corporate approaches to dispute management, because there's a lot more happening now, unlike the traditional litigation and arbitration. We've seen mediation and some other things, and I'll touch on that in a few minutes. Then look at comparative global African perspectives and African perspectives. And finally, challenges, reforms, and future direction. How can we position ourselves to be a part of this global phenomenon? Yeah, okay, so in terms of introduction to maritime shipping and trade routes, so the maritime industry, essentially, what I will be focusing on is on the commercial aspect of it. So there's the public side of maritime, which is where you have the Navy and issues that have to do with the security of the territorial waters of a country. But as far as this particular webinar is concerned, I would limit myself to commercial shipping. In other words, the carriage of goods and services. When I say services, I mean people from one port to another or from one country to another. Now, in terms of carriage of goods, whether it is containerized, whether it is your dry bulk, whether it is iron ore, coal, grains, or it is crude oil or liquefied natural gas or liquefied petroleum gas, all of these different types of shipping transactions cover over 80% of global trade by volume. So in terms of tangible goods and having to move tangible goods from one point to the other, maritime dominates in terms of carriage of goods. Now, when we're talking about shipping, we're talking about container ships, we're talking about tankers, we're talking about bulk carriers. Container ships are the ships that we are more familiar with when we talk about the maritime space, because most people have seen containers that have cars, that have electronics, but the maritime space is much wider than just containerized vessels. We also have tankers, which carry what we call dirty and clean oil. Clean oil is like your edible oils, your corn oil and the likes. And dirty oil, or the way it is categorized, is like your crude oil, of course, non-consumable forms of oil. Then you have your bulk carriers. It could be iron ore, it could be grains, and iron ore is the backbone of the steel industry. The steel industry is the backbone of construction. So you sort of understand how that chain, that supply chain that starts from maritime, really just cascades into other areas of our lives. Now, in terms of maritime, just like you have roads for cars, you also have routes for ships. So I'll just briefly talk about the famous ones. We have the Suez Canal, which handles container vessels and tankers, essentially connecting Europe to Asia. So prior to the creation of the Suez Canal in the early 19th century, the route was through the Cape of Good Hope, which was through the tip of South Africa, moving from Europe to Asia. Now, the Suez Canal is in Egypt, and it essentially moves from the Mediterranean Sea in Europe into the Red Sea, and then essentially opens Europe to Southeast Asia. So it's cheaper for vessels to move through that route than having to go all the way down the Cape of Good Hope at the tip of South Africa back to all the way to Asia. Then you have the Panama Canal. The Panama Canal connects the Atlantic to the Pacific. Essentially, again, bulk carriers, liquefied natural gas, container ships, and it connects the west part of the US to the eastern part of the US without having to go down through South America. So for production lines within the US at the western side of the US can carry their goods all the way to Europe without having to go down South America. So the Panama Canal helped with respect to movement in that space. Then you have the famous Cape of Good Hope, which was essentially the route that most movements, especially during the colonial times and then later on during the boom of trade and industrial revolution, was the major route between Europe and Asia, and indeed between Europe and Southern Africa. As a matter of fact, it was initially called the Cape of Storm, but when people began to see the amount of wealth they could create from being able to navigate that space, it became called the Cape of Good Hope. Mr. Mark. So now that we sort of have an overview of how maritime moves, and it's a very, very brief overview, maritime industry is a lot more complex than what I just mentioned, but that we can just use that as a mental gauge on the kind of work that arises from maritime in terms of shipping operations, in terms of maintaining ships, in terms of crew, the persons that will run the ship, in terms of the persons that will be from one port to the other to manage the arrival of the ship and the departure of the ship, the berthing and the onboarding, like we normally say in the industry. Now, the maritime and logistics industry, and when I talk about logistics, I think I should touch a bit on this. We're looking at multimodal means of transport and also connecting shipping to other forms of transport. So what do I mean? When a ship, for instance, I'll give the example of the Apapa port in Nigeria. When a ship berths at the port, the cargo is discharged and taken into the hinterlands to the bonded warehouses. For some places, they might have train tracks. In some countries, they might have train tracks from those bonded warehouses that take the cargo to the final consumer. Now, in terms of how logistics is changing, we are now having contracts of carriage of goods where you are doing door to door, which essentially means that you are taking it from one seller all the way to the buyer without having either of them having to engage throughout the supply value chain for the transportation. So let me give an example. Someone buys cars from South Korea for Nigeria. So the vessels would most likely be carried in a ro-ro ship, which is a vessel that allows for cars to be carried into a ship using its own wheels, which makes it easier than having to get too many containers, depending on the kind of car. So let's say it's a tractor, a number of tractors. So you're coming from South Korea, you're going all the way to Nigeria. There is a number of different stops that would be made all along the way. But more importantly, it is going to be from the ship to the road, to the bonded warehouse, to the final consumer. Now, why is ADR now important in this value chain that I just gave? Number one, ADR directly affects trade efficiency. So, for instance, the car gets to Tinkan and the tractor gets to Tinkan and it's found that one or two of its wheels have been damaged. The question is, at what point was it damaged? Was it at the point of the loading? Was it at the point of discharge? Was it during the voyage? Having to itemize the place of liability can adversely affect the ease with which businesses can handle transportation of goods from one point to the other. So by allowing for ADR, that's either arbitration or mediation, you can handle those trading efficiencies by quickly resolving the dispute without having to go through the long processes of having to file process in court and having to get lawyers and the likes. The other thing is that it improves investor confidence. So I would be talking on the standard forms in a bit, but how it builds investor confidence is that the disputes are resolved as quickly as possible and in a confidential manner. So in mediation, you have the mediator who is trying to essentially get the parties to agree and sign a settlement agreement. In arbitration, you have the arbitrator who makes the decision between the parties. But the crux of it, or whether it's even any neutral evaluation, the crux of it is that it is confidential. And so that helps the investor to be assured that even if disputes happen, if I invest in a particular ship and the disputes have happened with respect to the cargo that it carried to a particular country, it will be resolved quickly, it will be resolved amicably to ensure continued trading, because without continued trading, you cannot have profits. Without profits, you cannot have returns to your investors. So the ease with which ADR helps the conflicts or the disputes to not become a clog in the trade transaction, the more the investor is confident in investing, because they are sure that their returns on investment will not be hindered by taking the matter to court and spending time in court on such issues, especially when you have an issue such as ship arrest. A very large crude carrier, which is a vessel that carries crude, is rented on an average $100,000 per day. And so if it is arrested in a particular port, it means that for each day that it is berthed in that port, it is actually losing $100,000 to its owners. So you can see that it can get really complex if things are not resolved as quickly as possible. Then supply chain resilience. ADR helps to ensure that there isn't a clog in the wheel in terms of the supply chain. So the tractor moves from South Korea, comes into Nigeria, and there is port congestion. How does the shipping company ensure that the owners of the cargo are able to agree if there is a demurrage or anything of that nature? So it helps to ensure that supply chains are not adversely affected by the by disputes that may arise in the course of the transportation. Now, dispute resolution in this context, as I have just outlined it, shows itself as a pillar of global trade governance. So it helps to govern the speed at which transactions can continue without having to be adversely affected by the fact that a conflict, which may inevitably arise, arises. Yes, Mr. Mark. Now, in terms of the evolution of dispute resolution in maritime and logistics, there's been a huge shift from court litigation to arbitration and mediation. And as a matter of fact, we understand, especially during the celebration of the International Chamber of Commerce Court of Arbitration, that the earliest arbitrations were actually maritime arbitrations. So the maritime practitioners had found ways more than 100 years ago to try and avoid courts as much as possible because of how expensive the industry is. It's a capital intensive industry, and the last thing they want is for their matter to be in court, where lawyers are trying to prove the position of the law while they are losing money waiting for the decisions to be made. Now, because of historical maritime activities, you have spaces like London, Singapore, Hong Kong, Paris, and New York as being established global hubs for maritime arbitration and mediation, really because they are actually global maritime hubs in terms of transportation. So shipping is a derived industry. If you don't have goods that you're carrying from one point to the other, you don't have shipping. And so without shipping, without the transactions, without the trade, you cannot have the dispute. And so the global maritime hubs have also turned out to be the global hubs for maritime arbitration and mediation. And the other, just to reiterate, additional benefits of ADR, the neutrality, the third party who has no interest in the dispute beyond helping the parties to resolve the dispute, whether it is as a mediator or as an arbitrator, then the confidentiality and enforceability. So under the New York Convention, you have the enforceability of foreign arbitral awards, and under the Singapore Convention, you have the enforceability of international mediation settlement agreement. Mr. Mark, the next slide. So key drivers of disputes in global trade. Because of the way shipping is, shipping from one country to another, each country has its own peculiar jurisdictions. Each country has its own rules and regulations. Then there are international conventions on top of all that govern the transaction of carriage of goods by sea. And this creates a lot of complexities. So you have multiple parties, you have multiple jurisdictional agreements, then you have operational challenges. So if a vessel, while on the high sea, has an engine problem and they are not able to get to berth on time at the port of destination, the question then is who is going to be liable in the circumstances? So you have issues of engine delay, issues of engine problems. Then you have port congestion. If the vessel gets to the port on time, but because the ports are congested, who is meant to handle the cost of that congestion? Then the delays, cargo damage. When a cargo is damaged, you have to find out through the chain of causation where that damage happened. Then you have regulatory pressures from conventions, the different conventions, especially the ones that have been put out by the International Maritime Organization. And then you have sanctions, you have customs compliance issues because different customs in different countries have different rules and regulations. Although they have uniform rules, but how they are applied is different in different countries. And so that also creates another layer of complexity. Then you have external shocks, one of the most recent of which has been the COVID-19 pandemic, which really tested what it means to have a force majeure clause in your contract. What does that mean? How does that affect the final outcome of the dispute resolution when it has to do with something that was completely out of the contemplation of the parties when they were drafting those contracts? And then you have trade wars, which we have seen happen over and over again, especially with the current US administration. And then we have the issues of actual wars, like the war between Russia and Ukraine. Before the war between Russia and Ukraine was one of the world's largest exporters of grain. And that adversely affected the global value chain of grain all around the world. And for countries that depended on Ukraine for grains, it made every other thing from bread to cakes to pastries very expensive. And so that, of course, affected the household income of many middle class people in most countries all over the world. Just to tell you how interconnected all of this can be. Yes, Mr. Mark, next slide. Then, so in order to make the industry fit for purpose in sense of having to ensure that monies are not lost on the altar of dispute resolution, there has been many industry-specific contracts and ADR clauses to address these issues. So you have BIMCO, the Baltic International Maritime Organization's forms, GenCon, NIPE, Supply Time, and these are under charter parties. Now, what are charter parties? When a vessel is being used to carry cargo from one port to another, the ship owner will not always have the cargo owners who want to use their ship. So what they do is they charter it to a third party who has people who want to cargo their vessels with the person or with the entity. So it can either be a time charter where the ship is chartered for a period of time. The equivalent is when you hire a car for maybe a day, or you can have a voyage charter, which will be based on where the vessel is going. So the example is maybe you are taking, maybe you charter a car from one place to the other. And then you have the third type, which is a bareboat charter, where you charter the boat, the vessel for an extended period of time. And you are essentially, the correlation would be if you're having sort of like a finance or an operational lease in accounting terms. So that is what a bareboat charter arrangement is like. Now, BIMCO is the organization that handles over 70% of the standard forms of contracts in the shipping industry. And so for the different types of charters agreements that BIMCO has designed, many of them have not just arbitration clauses, but also mediation clauses. In fact, for some of them, they insist that there must be evidence that mediation had been attempted before going into arbitration. Then you have bills of lading. Bills of lading is essentially evidence of the carriage of goods. The bill of lading itself is not a contract of carriage, but it is evidence that goods were carried. And so there are various international conventions that talk about the legal rights and obligations under the Bill of Lading. So you have your Hague-Visby rules, your Hague rules, your Hamburg rules, and your Rotterdam rules. The challenge with these different conventions is that different countries have chosen which ones they want to adopt based on which best suits their country's interests. So we've seen countries that would sign up to conventions that is more skewed towards cargo owning countries, and we've seen countries that have signed up to conventions that are more skewed towards ship owning countries. So that again creates a discrepancy in terms of the what what and how liability should be established in different countries. Now, for shipbuilding contracts, you also have different standard forms, and those ones as well has ADR clauses in them. Now, some of these ADR clauses have institutions where the matter should be taken to by default. So you have the International Chamber of Commerce Court of Arbitration. This is particularly for FIDIC contracts. The default institution is the ICC. For the London Maritime Arbitrators Association, the most VIMCO contracts have that the association as the default association. Association's rules to govern the disputes that arise with respect to that with respect to that shipping transaction. The same with the Singapore International Arbitration Center and the Norwegian Center as well. Mr. Mark, the next one, and I'll try and be as quick as possible now. Now, other industry-specific ADR clauses are, in particular, the BIMCO ADR clause of 2021. Now, this clause, which again, like I said, makes up 70% of shipping contracts around the world, has specifically stated that there must be evidence of mediation, early intervention, or early neutral evaluation. There must be evidence of these three, any of these three, before a company would go to court. Would go to arbitration under the standard contract. And as a matter of fact, they do not contemplate the possibilities of going to court, but it does happen. But the idea is that even arbitration should be avoided as much as possible, just to ensure that the disputes are resolved as quickly as possible. Again, because of reputational risk, because the maritime industry is a very capital intensive industry, and so there are not many players in the space. And the last thing a company wants is to lose out on on continuous transactions or continuous trade with a particular trading partner because of a particular dispute. So the general tendency is to go towards faster and more flexible dispute resolution alternatives in terms of like early neutral evaluation. Now, again, for charter parties, bill of lading shipping contracts, they also now include pre-agreed dispute mechanisms. So there is no longer the issue of we will wait to when the dispute arises. If the dispute arises, we will then determine how we would resolve the dispute. That's no longer the case in majority of the maritime contracts. Most maritime contracts now have a pre-agreed dispute resolution mechanism, and sometimes it's three-tiered. So that could start with negotiations, mediation, and then arbitration. Again, like I said, the contemplation is not for shipping companies to go to court. Then for port construction and PPP contracts, you have FIDIC, you have the arbitration boards, the dispute management board, the dispute adjudication board, and most of these standard contracts again say that you must first go to mediation. The idea again being to be able to resolve the dispute as amicably as possible to retain the reputation of the parties and to ensure a continuity of the trade relationship. In terms of global and African institutions and associations, we've seen ICC, the London Court of International Arbitration as well, the LMAA, the Singapore International Arbitration Center. But I want to just quickly touch on a few African institutions. We have the Regional Center for International Commercial Arbitration in Lagos and the Nairobi Court of International Arbitration, and indeed the Asia Court of International Arbitration. All these institutions and the Cairo Regional Center for International Commercial Arbitration all came out of the non-alliance ALCO agreement, which was an agreement between Asia and Africa to essentially create a platform where disputes can be resolved without having to necessarily go to the global north. And so you have these institutions trying to build on the capacity that they are more experienced than older arbitration institutions have had. And so we are seeing more and more of maritime related, specific maritime related panels being discussed and being put together under these various arbitration bodies. As a matter of fact, the Dubai International Arbitration Center has also created rules specifically for port-related disputes, just to reduce the advent of arbitration and to encourage the use of settlement and mediation, and of course, negotiation. Then we have the Maritime Arbitrators Association of Nigeria, which is working with the Nigerian Shippers Council to create a platform for the resolution of disputes within the trade space as quickly as possible. Now, in Nigeria, the Nigerian Shippers Council is the regulatory authority that oversees the issue of the cargo owners' interest. And since Nigeria is more of a cargo owning nation, it is so much more important for the Nigerian Shippers Council to be able to help cargo owners address issues of disputes as quickly, as efficiently, and as economically as possible. Next slide, please. Okay, so what are some of the policy and corporate approaches to dispute management? I call it dispute management because at the end of the day, some of these disputes, the idea is not for it to even get to the point of resolution, but to be managed so that it doesn't escalate to the point of having to be resolved. And so for governments, especially in the African space, we are seeing more and more promotion of arbitration and mediation. And a great example is the Nigerian National Arbitration and ADR Policy 2025, which was passed last year. We also have the Ministry of Marine and Blue Economy in Nigeria passing a policy on the marine and blue economy. In Kenya, we are seeing more and more of a shift towards increasing the use of mediations as far as shipping transactions are concerned. We're also seeing a similar trend in South Africa. And many African countries are aligning their arbitration laws with the UNCITRAL rules. And I must also mention that UNCITRAL, especially in its Group 3 discussions, have looked at ways in which investor-state disputes can push forward the use of more and more mediation with respect to trade disputes, whether they are maritime, whether they are telecoms, regardless of the sector that it is in, to increase the use of mediation. And the International Center for the Settlement of Investment Disputes, ICSID, under the World Bank in 2022, also released its mediation rules. Again, the idea is to increase the use of mediation and negotiation to resolve, not just resolve disputes, but to manage disputes so that they don't even get to the point of having to resolve it. For companies in the shipping industry, there is now a more deliberate attempt towards drafting. And this is particularly important with insurance companies who would insist that certain standard templates be used so that they can use that in terms of risk allocation and to understand what their exposure is with respect to different transactions that they are insuring. So we're seeing a lot of companies adopting standard templates, having multi-tiered dispute resolution clauses, and having to use ADR as a strategic risk management tool. In other words, how much in time in cost are we looking at if a dispute escalates beyond mediation? And so it is important now for companies to be able to manage their exposure to the complexities and the cost implications of dispute resolution because of the the escalating costs that can come out of not just losing trade partners, but also losing valuable time in trying to resolve a dispute. And so we are seeing discussions about joint ADR centers. So the Maritime Arbitrators Association of Nigeria are having discussions with the Nigerian Shippers Council. The Federal High Court in Nigeria that has jurisdiction to hear maritime matters launched its Alternative Dispute Resolution Center in 2021. And so we are seeing more and more need for having to take maritime matters out of the courts into the ADR centers. The next slide, if you want. Okay, so let's talk about the elephant in the room, emerging technologies and corporate practices. I call it the elephant in the room because I've heard a lot of times when mediators and arbitrators are wondering, is AI going to take over the ADR space? So before I answer that question, which I'm sure is going to be a controversial question that we're going to have to come to, there are a few innovations that have happened in the maritime industry that has made it imperative that those in dispute resolution space understand what is happening. So now you have more digital bill of lading, which also means that it's no longer the paperwork, it's no longer even the emails. It is now there are now digital bills of lading that have less of the regulatory bottlenecks that you have in certain jurisdictions where we used to have paper-related bills of lading. Then you have blockchain tracking. You have AI contract analysis. Now with blockchain tracking, you are having cargoes being tracked through blockchain and through artificial intelligence, so that you can tell in real time when a cargo has issues, or maybe there was a problem with the cargo. So for instance, a grain cargo, if you're using AI to track the cargo, you will be able to tell when it starts to mold. Maybe the moisture within the container was not, or within the hold where the grains was put into, was not properly dried out before the grains were put into it. So the change in atmospheric, the atmosphere around that hold will be easy to track, and you can immediately tell at what point the cargo started to decay. And so that really helps in terms of having to allocate liabilities. Then in terms of AI contract analysis, it makes it easier rather than having, unfortunately, I have to mention this, rather than having 10, 20 lawyers sit down with a contract, you actually can have an AI contract analysis software that will analyze the chain of causation and the places of liability and the likelihood of the liability through the chain of through the supply chain process of a particular contract. And so we're seeing more and more of this AI contract analysis. Of course, we're having virtual hearings, online ADR platforms, which is the platforms we have here. Then we have predictive risk analysis. These are all tools that are being used by the in-house counsels and also the in-house dispute resolution team of companies. You have internal mediation teams. You're having major companies having internal mediation teams having to mediate where there are issues with respect to the operations of the vessel, especially in companies that have many vessels. And then you have collaborative negotiations that, before this matter becomes an issue, let us have discussions on it and then make a decision with respect to that. Then you have the role of insurers and P&I clubs in dispute resolution. So in maritime, insurance is both the insurers against third-party damage, that's maybe the cargo owner, and then you have insurance with respect to the hull and machinery, which is with respect to the ship itself. And insurers are increasingly finding ways to ensure that they minimize the risk exposures that comes out of the operational issues that can come out in the maritime space. So the next slide, and I hope I'm trying to wrap it up as quickly as possible now. So I'll just quickly talk about the African regional framework. You have the African Integrated Maritime Strategy 2050, which is really about the African maritime domain. How can we ensure that we can make Africa's waters and oceans work for Africa? And this is under the African Union's Agenda 2063, which is a prosperous Africa for all. So it's an aspect of the bigger picture of the African Continental Free Trade Area Agreement. So when we're talking about integrating Africa via trade, a major part of that is having to integrate the African maritime domain and having to connect African countries across the entire African coastline. Out of 54 countries in Africa, 38 of them are coastal states. So you have more coastal states than you have landlocked states. And so being able to handle or have harmonized regime in terms of logistics between those that are coastal and those that are inland will be very instrumental in ensuring that the African Continental Free Trade Area Agreement actually works. Then you have regional ADR centers. I've mentioned the Regional Center for International Commercial Arbitration in Lagos, and then the Nairobi Court of International Arbitration in Kenya. Then we need to be aware of the challenges. One of the major challenges is awareness about ADR as far as shipping is concerned, because most of the disputes are taken to the major maritime hubs. And of course, it would be the experts available in those spaces that will be able to handle those cases. And so you have that issue of lack of adequate competence. And also lack of, even when you have the competence, lack of the cases to be able to build expertise. Then you have issues of enforcement, having to enforce arbitral awards or having to enforce mediation settlement agreements. Again, this comes to an issue of awareness, which can be addressed by capacity building, which I'll come into in a few minutes. Now, judicial backlog, again, the challenge of having to take simple or, well, in the maritime industry, you can't exactly call any contract simple, contractual obligations to court, and then having to have that being tied down with every other work that the court is involved in. Next slide, please. So what are the strategic opportunities? It's not all doom and gloom when it comes to Africa. So capacity development for judges is extremely important. Judges should know when a contract says or when a standard contract form says it should go to arbitration, it should be sent to arbitration. When lawyers try to bring in matters that they want to sort of use to stop the arbitration from proceeding, which is commonly referred to as guerrilla tactics, it is important for the judges to identify it and to allow the cases to go back to arbitration and to be quickly addressed at the arbitration stage. Then arbitrators themselves need to understand the powers that they have, and they need to understand it in the context of the arbitration laws in the countries that they are practicing in, or under the rules of the arbitration institutions that they have been appointed under. And then for practitioners, arbitrator advocates, and for mediator advocates, there's a need to train lawyers in that space so that they are partners in progress rather than a clog in the wheel. Then the creation of regional maritime arbitration hubs would help to consolidate the different cases that involve African parties, whether it's an African ship owner or it's an African cargo owner. Because at the end of the day, if you keep exporting the disputes outside the continent, it deprives us not just of the expertise, but also of the jurisprudence, so to speak, of being able to handle cases in this space more and more. So if we have to keep waiting till the matters are resolved in international spaces, there's also the time that is involved in that, not to talk of the expense of having to spend in foreign currency. Then legal and regulatory harmonization. The African Continental Free Trade Area Agreement does have a dispute resolution mechanism, but it is focused on state to state. So the question is, how does that address private to private entities that are building their businesses on the basis of intra-Africa trade? Then digital and online resolution systems. We need to improve on our IT infrastructure to ensure that we can be in the place of play when the discussions on these issues are taking place. So more and more African countries should seek representation in spaces where the discussions on technology, on IT, on maritime is taking place. And that's why I'm very excited that Nigeria is finally, after almost 2 decades, a member of the International Maritime Organization's Council. It's very important that more and more African countries are in that space to discuss the issues that affect their own countries. And then public and private sector collaboration should increase so that more and more individuals and entities that are adversely affected by issues of dispute resolution in the maritime space can have both government backing and the backing of the expertise in the private sector working in their favor. Yeah, Mr. Mark. Okay, so further directions, hybrid ADR models, combining mediation, arbitration, and technology. So more use of online mediation, even if you have to use the international centers. If you can do that with your online platforms, it also reduces the cost exposure that comes from resolving the dispute. Africa-based institutions to strengthen trade and investor confidence. There shouldn't be a discrepancy in government policies when it comes to trade, and there should be consistency when it comes to maritime, especially. Then the use of ADR as a strategic enabler. So rather than just seeing ADR as a tool for dispute resolution, it is important to see ADR as a strategic enabler of global commerce, sustainable development, and supply chain resilience. Next slide, sir. So in conclusion, maritime and logistic disputes are inherent in global trade. As a matter of fact, at least 20% of maritime contracts are going to end in some form of dispute or the other. Efficient resolution is critical to economic and trade policy goals. Arbitration and ADR dominate global best practice, again, because they are able to circumvent the court systems in the countries and resolve the disputes, hopefully faster, especially when it comes to arbitration. Then there's a need for Africa to continue to strengthen its institutional frameworks. It should be institution centric, not personality centric. So it's important that institutions are able to stand with minimal interference from government or even strong private institutions. And then the future lies in reform, capacity building, and innovation. Like I said in the beginning of my, I think I said it in the beginning of my presentation, Africa has the highest number of under 20 years generation in the world. And so these people are going to need houses, they're going to need clothes, they're going to need cars, they're going to need trains, they're going to need infrastructure. And at the end of the day, these tangible goods are going to be carried via ships. And so it is important for Africa to take its place in the place of play and also to not be a hindrance to global trade in trying to ensure that it improves its position in the scheme of things. Thank you very much for listening.
Thank you so much for that very informative and educative presentation, Ms. Foluke. We truly appreciate it. If you'd allow me to ask one quick question before I open it up to the audience, and it might be from a personal perspective, but I'm sure it might be very helpful to other attendees as well of this webinar. As I just wanted to find out, what advice would you give those who are starting in practice or looking to get into practice, particularly as it relates to ADR in this area in maritime and logistics, or just ADR in general? What advice would you give us, if I can put myself in that category, and also to build a successful practice as you have, and to get some of the accolades you have? What sort of advice and really advice would you give us to those in that position?
Sorry to interrupt.
Yeah.
Would it be possible if
Okay,
Foluke
so
stops
okay.
sharing her slide so we can see her fully? Thank you very much. Please go on.
Okay.
Yes.
Okay. I don't know if we can still see and hear me.
Yes, we can.
Okay. Okay. So that's a great question. The starting point is to be amongst people who are doing what you want to do. So yes, you can have all the training, and I will talk to capacity building is extremely important, and I will talk about that. However, it's very important to be amongst the people who are doing the things that you want to do. So if you want to be an arbitrator, join the arbitration associations around you. You want to be a maritime arbitrator, join the maritime arbitration associations around you. Because at the end of the day, you can have all the knowledge and all the understanding of what the disputes in a particular space is, but if you don't have the people to guide you, or if you don't have the people who are already doing it, it will still be head knowledge. So try and get mentors, and try and ensure that you volunteer in organizations associations that you join, because these help you to give real life experiences. And so in the beginning, you may not essentially make money from the associations that you join. And I know that sometimes this might sound like cliche, or you don't make money in the beginning, but it really is because just like if you plant a cocoa tree, and forgive my using cocoa, it's indigenous to me. So a cocoa tree, I understand, takes about 15 years before it starts. Is that 5 to 10 years before it starts to grow, and then or rather bear fruit, and then it takes decades before it stops bearing fruits. What does that mean? It means that there's a time for growth, and that time for growth is the time when you don't make money. So it's not as if it's cliche, or you're trying to discourage people by saying you may not necessarily make money at that time. It is because it's the truth. Because building capacity is far more important than making money at a stage when you can actually ruin somebody's life savings on a business. So for lawyers, join law firms in the maritime space and learn what contracts are about. For those who are non-lawyers, maybe like accountants, join the shipping operation, join a shipping company, and be in their finance space, understand how the finances are done, understand what operations are. If you are an engineer, or you are a maritime surveyor, or a marine surveyor, sorry, join shipping companies and get that experience. Arbitration, I've come to realize, is almost like a retirement job. You must come into it with some level of expertise, because you cannot be resolving disputes you don't understand the facts. So the other thing is that get certifications. So the first one I talked about was to join associations. The other is to get certifications. I'm a professional student member of the Institute of Chartered Shipbrokers in the UK, and joining them has helped me to understand the maritime industry on a totally different level, because it is pure shipping. This is not um, a derivative of trade. This is shipping operations. How does a ship work? How do you draw a ship? How do you identify a ship? How do you know that a ship is a Handymax, is a Panamax, or is it Aframax? How do you identify that it's for wet cargo, it's for dry cargo? How do you identify the trade routes that could become problematic over a particular point of over a particular period of time, as we have seen with the Russia-Ukraine war? The other thing is get technical knowledge. So even if you can't necessarily do something like the Institute of Chartered Ship Brokers, there must be a university around you that does training on logistics, or maritime and logistics, or just logistics, because there's no way you will study logistics in international trade that you will not touch on maritime. So first and foremost, get into the space where people who are doing what you want to do are already doing it. Number two, capacity building in the technical aspect of things. So whether you're a lawyer or an accountant, or a marine surveyor, or a naval officer, make sure you have the technical expertise that you require to be in that space. And then the other thing is, I really do want to encourage us to come into the space, because under the African Integrated Maritime Strategy 2050, Africa is supposed to take ownership of its waterways, and it's supposed to take ownership of not just ship ownership, but also cargo ownership, and also investing in the sector. Investors will not invest in a sector that is volatile, that is unpredictable, that is difficult to gauge entry and exit. And so the more of us that are aware of maritime related projects, or maritime related work that is being done in our various countries, the better for us. And the African Union, through AFTA, is looking at 2063, a prosperous Africa for all. So we can change the narrative of Africa being the problem child of the world, so to speak, but also more importantly, to build prosperity based on African resources. Now, this is not in any way to say that Africa should exclude itself from the global village. It is just to say that we need to take ownership of what is ours and be responsible with it. Because even though we may say that we have many foreign practitioners, the point is they've been responsible with how they have managed their own resources, and that's why they know how to manage yours. So we need to be responsible on how we manage our natural resources.
Thank you so much for that in-depth answer, Foluke. I'm sure a lot of us have gained a lot from what you've said. Allow me at this moment to open it up to the participants to ask questions. And as I do that, I see there's a question in the chat from Deborah. So just please allow me to read it out. She says, or Deborah says that, does the dispute resolution mechanism under the African Continental Free Trade Area tally with the current maritime dispute resolution mechanism operative in Nigeria?
Okay, so the way after dispute resolution mechanism is designed right now is purely public sector driven. So it's only state to state. So there's still there's the discussions on the investment protocols to after, and we're looking to see how that would pan out, because again, there has to be a way of addressing the issues with respect to private sector interests. But as it is for now, unfortunately, it is purely state to state. So no, it doesn't. It doesn't correlate with the maritime space in Nigeria or in any African country in the as far as the private sector is concerned.
Thank you so much. And Deborah, I hope that answers your question. I don't know if anyone else in the audience has any questions. Feel free to raise your hands or unmute. As we wait to see whether anyone else, I also had a question on the substantive presentation as well, and specifically where you are discussing about the effects of the importance of ADR to maritime and logistics trade efficiency, and how alternative forms of disputes have come in to sort of make it more efficient in that it saves time and that it's cheaper to resolve the disputes faster in order to promote this trade efficiency. And obviously resolving these conflicts in a quicker way. I just wanted to pick your brain on the reality of this, because one of the key discussion points that we're seeing around the arbitral space, especially as it relates to arbitration and not necessarily mediation, or I wouldn't want to comment on mediation at this point, but as it relates to arbitration, one of the key pointers we're seeing is that a lot of times, or in some cases, what tends to happen is that the party that loses or the loser in the arbitral dispute tends to immediately challenge that decision before a national court. And so with that then comes going through the whole arbitral process and then going through the court that has jurisdiction, be it the annulment court or the enforcement court, to then resolve the nagging issues. And so with this comes the added time and also added expenses, because now, in addition to funding the arbitration, the parties also have to fund the litigation part of the arbitration, if you get what I mean. So in reality, especially as it relates to arbitration in resolving these disputes, has it actually made things cheaper and quicker? Do the parties tend to tends to abide by what the arbitrator or the tribunal determine as part of the dispute?
Okay, so that it's a lot of questions packed in one, but I think in essence, we're saying are companies abiding by arbitral awards more now than now. The thing is, it depends on cost. I mean, when it comes to the money, people don't want to go to court. And yes, we do see, I mean, in Nigeria, we're seeing the trend where it's almost like taking a step to that arbitration is almost like taking a step towards litigation, that you just do the arbitration for the sake of it, just to go back to court. Now, what that does is that it sends a signal that your country is a difficult environment to invest in. And so, one of the things that for those of us in the ADR space are trying to do, especially on the platforms of different chambers of commerce, is to say, look, you need to be able to address your disputes as amicably as possible. The reason being that when you keep going to court, you are adversely affecting not just your trade relationship, but the image of the country as a whole. Because what then tends to happen is that you are encouraging more and more use of international tribunals. And the end game of that is you have to then look for the money to go and enforce your award or to challenge your award in the UK, for example. And so um, if the company has had to sign up to a standard form agreement that has the LMAA in there, you have to go to London to get it set aside. So it seems as if this level of having to go to court is more when the applicable law to the arbitration is an African country. They tend not to challenge it if it is not an African country. And so there is a need for us to respect our national courts. There's a need for us to look at the cost implication in terms of, do you want to continue doing business in this industry? If you want to continue doing business in this industry and your other party is an African party and you have agreed to have a Nigerian or an African country's laws to apply so that it is cheaper for you to resolve your disputes, it should also be resolvable, if you permit me to use that word. You cannot say that you are trying to avoid costs and put your national um, arbitration law in the contract, only for you to then lose out on the benefits in terms of time, because you then find it cheap enough for you to then challenge the award in court. Because again, like I said, when it is the UK, except for companies that really have the money to spend, when it's in the UK, the tendency is that they just let go and they let it be. So I think even from a national policy perspective, there's a need to address the frequency with which lawyers go to court to challenge arbitration awards. If I have in fact said in certain platforms that there should be, I mean, for the lack of not trying to be politically correct, there should be consequences to frivolous applications taken to court just to set aside an arbitral award that was most likely well considered, especially when you have an experienced arbitrator that had handled the award. Every award doesn't need to be challenged. There needs to be real reasons for you to challenge it. And the Arbitration and Mediation Act of 2023 in Nigeria has actually narrowed the areas within which an award can be challenged. However, despite that, and I've had to sit on a number of arbitrations, and I can tell you that, despite that, almost every arbitration I've had in the last 2 years has ended up in one form or the other in court. And the problem with that is that we are not sending the right signals to foreign investors, because nobody wants to put their money in a space where there is a lot of uncertainty.
That's true. Well put. And allow us to take maybe the interest of time, allow us to take the final question from Yetunde. If you could kindly, yes.
Hello, everyone. I do not have a question. I have a comment. Can I go ahead?
Yes, of course.
Thank you. So I want to say thank you so much to Madam Foluke for the invite. And thank you for the insightful and well-structured presentation. It's good to see that your push for mediation, an alternative dispute resolution has continued. It's very interesting that in the maritime sector, people still want to go to court when we have seasoned arbitrators like yourself. I especially like your response to Mark's question, when he was talking about how to get involved for those who are not knowledgeable, and your push for capacity building is very important, and also being part of industry associations. And thank you for the reminder of Agenda 2063 for Africa's oceans and seas. We need to take advantage position, so that's very important. And lastly, I want to say that as a member of Women in Maritime Africa, Nigeria chapter, we're very proud of you for your outstanding work in maritime arbitration and mediation.
Thank you.
And this is a powerful example of your leadership and the expertise women bring to the maritime industry. So thank you very much and well done.
Thank
Thanks
you.
to the organizers as well.
Thank you, sis. Thank you.
Thank you so much, Etunde, for those excellent observations and comments. And I think it's an excellent way to end this conversation with Ms. Foluke. Thank you once more for your insightful contribution to today's webinar and enlightening us on various aspects. And I'm sure we're all better off now than we were before we started this webinar. So thank you once more, Foluke, for an excellent webinar. Thank you. And allow me to pass it back to Prof. Nyema for final words.
Thank you. It's just to add many more thank yous to Foluke and to yourself, Mark, and to our audience. I'm quite pleased that people are still with us. Thank you very, very much, Foluke, for that encouragement and sharing on how people can get involved in this. That's really important to us and to our members. And so thank you very much, everybody. Our next webinar is on the 10th of February, and it's going to be on mediation. So it's going to follow through as Foluke has started the discourse around mediation, but we will send out information. Do all have a lovely evening, morning, afternoon, whichever one it is where you are. For us, it's lunchtime, so we're off to lunch. Thank you.